Welcome everybody. It's now 2 minutes past 4 and welcome to this, one of the final panels at this year's Refugee Law Initiative conference. Thank you very much for joining us for this panel. If you don't know me, my name is Professor Cathryn Costello. I'm Professor of Fundamental Rights at the Hertie School in Berlin. And we're convening a panel today on the role of UNHCR in refugee status determination. So we have a great panel assembled, and I'll introduce the speakers as I introduce their papers. As you know, if you've joined other sessions in the conference, these sessions are being recorded. So if you're not comfortable with that, then I suggest that you don't stay for the session. But we're grateful to the Refugee Law Initiative for putting this conference online and also for making the proceedings available afterwards. I know a lot of us are zoomed out, so we're going to keep our presentations to time to enable discussion. Again, as you know from the previous sessions of the conference, you'll be able to type questions in the chat and I'll put them to the panelists. And we, as you know, we have 4 papers. Each of our speakers, each paper is going to be given about 10 minutes, and then we should have ample time afterwards for discussion. So as I said, I'm not going to dwell on the formalities. I'm going to immediately introduce our first speaker. We have Dr. Alice Na from the University of York, and Alice's paper looks at UNHCR in Malaysia, Mandate and Protection Obligations Explored. So I'll hand over directly to Alice.
Thank you, Cathryn. I'm going to share my screen and then put the slides up. So I hope that it's visible for everyone. Just give me a second. Can everybody see that? Yeah? Is that all right? Okay, so thank you very much, Cathryn, for organizing this panel and inviting me to be part of it. I'm going to focus on UNHCR's operations in Malaysia, and I've been studying UNHCR, but also how we, sort of get refugee protection done in complex situations where there's mixed migration flows. And Malaysia has been a case study I've been following out of personal interest for about 20 years now, first as a practitioner and then as a scholar. And I take very much a sociological or a political approach to this work. So you'll see in my presentation that I'm not speaking as a lawyer, but as someone who's trying to understand how protection works, looking at social and political factors, always with a motivation to understand how we can strengthen refugee protection in contexts like Southeast Asia. Right, so what is the role of UNHCR in a place like Malaysia, where there's mixed migration, is a complex mixed migration context where a state has not signed the 1951 convention? And in thinking through this problem, it's a question that's relevant not just for the way that we understand the role of international organizations, in particular UN agencies at the domestic level within a state, but also, it raises questions around the global migration governance, the way it's organized and the way it's disorganized. And actually, I've been thinking about this problem through Slaughter and Crisp's reflection of UNHCR as a surrogate state. And they describe UNHCR as taking over the role of a state when the state is not willing or unable, to play a strong role in refugee protection. And they describe UNHCR as being complete with its own territory, citizens, public services, and even ideology. And I think, sort of reflecting on this role that UNHCR takes when the state does not want to fulfill its, obligations or take on the role of refugee protection, what dilemmas does this cause for UNHCR? And in fact, Sarah Miller looks at this question in a very different context in Kenya, Tanzania, and Uganda. And she argues that international organizations like UNHCR, when they take on surrogate state properties, they tend to have less influence on the states in which they work. And according to Miller, this occurs because of the marginalization of the state from refugee protection operations and responsibility shifting. Yeah. And Miller argues that marginalized states are incentivized to maintain the status quo, and benefit from letting UNHCR assume the costs and the work of protecting and caring for refugees. And in context where UNHCR plays this stronger surrogate role, UNHCR can actually find it harder to influence states because as states abdicate their responsibilities, UNHCR steps in to fill the void, but then also tends to take the blame for whatever goes wrong. States become disinterested in refugee affairs, and UNHCR is forced to hold back from its criticisms in order to maintain access to refugees. And this is an example of a protection dilemma, which I'll come back to at the end of this presentation. So in the context of Malaysia, we do see that UNHCR takes on properties of a surrogate state, but it does so without refugee camps. So without a territory being clearly defined, with ambiguous authority and not clear, sovereignty that isn't clearly defined. And so with this lack of clarity of its role and powers, it's really up to UNHCR to negotiate and bargain sometimes for protection space, to create protection space. And in this ambiguity, UNHCR has been able to gain ground in refugee protection in a place like Malaysia, but this protection space requires constant negotiation, and it is up to UNHCR officials, it depends on their entrepreneurial skills, how far they're willing to create a protection space for refugees. So what is the context in Malaysia? I think first of all, it's to recognize that it's a very dynamic context with at least 2 million documented migrant workers and another 2 to 4 million migrants with irregular status. And UNHCR has registered about 180,000 persons of concern, but thousands remain unregistered. It's a protected refugee situation. Malaysia is not a signatory to the convention and does not have domestic laws concerning the rights of refugees and the institution of asylum. And it's a really hostile environment for migrants with irregular status and poor protection even for those who are documented. So migrants with irregular status are stigmatized and criminalized. There are high-profile immigration raids, public crackdowns aimed at instilling fear amongst migrants. The arrest and detention and deportation of migrants is used as a way of deterring and punishing migrants, and that affects refugee populations as well. The impunity for crimes against migrants and refugees is high. There's a high amount of trafficking. Documented migrant workers themselves, even though they have documents, struggle with access to justice. And so becoming irregular becomes a way that they escape forced labor and exploitation. And all of this occurs even as the Malaysian economy is quite dependent on the labor of migrants, both documented and irregular. So what's UNHCR Malaysia's role? So it began in Malaysia in 1975 in response to the Indo-Chinese refugee crisis. And in the 2000s, it shifted its strategy, providing a much more diverse range of protection interventions and support for the services and programs for refugee communities. So its activities range from registration to RSD in different forms to resettlement. And a very important protection intervention they did was to intervene, when refugees were arrested, and to sort of try to extract them out from detention and to escape a deportation. As a UNHCR officer observes in a report by UNHCR, because the support for refugees is so limited here, we also find ourselves dealing with a lot of individual problems. Women whose husbands have gone missing, refugees who want to find out more about burial arrangements for deceased relatives, and workers who have not received their wages, for example. This all places extra pressure on the office. So its approach really is kind of to create small exceptions, exceptions for a small number of people compared to everyone who's affected by Malaysia's fairly harsh approach to regular migration. And its practices are quite resource intensive. It's case by case, person by person, trying to get them out of hostile situations and to afford them some protection. All of this with insufficient resources. So if you look at the past few years, the amount of funding it has for its needs is probably about half or slightly less than half. So what are the challenges in fulfilling UNHCR's mandate? So it's tried a range of protection interventions and advocacy approaches. And in the last 20 years, some of them have not been ideal. They're often in tactical response to the action of states and non-state actors. yeah, who creates a hostile environment for refugees. And the practices are quite significantly influenced by domestic politics and state practices concerning irregular migration. These in turn are shaped by Malaysia's economic growth model and corporate interests, the desire for cheap and disposable labor, and rising levels of xenophobia, in particular when it links to election outcomes. State interest in the region concerning refugee protection also influences its action. And in Southeast Asia, Australia plays quite a strong role in sort of trying to keep populations away from Australia and contained in Southeast Asia. And that opens up, creates advocacy options, but those advocacy options are limited, yeah, strongly driven by strict state interests rather than the standard or the principle of refugee protection. And what we observe in Malaysia is that while globally UNHCR may have broadened significantly its focus beyond its core mandate to force migrants, in the face of scarce resources and in mixed migration contexts like Malaysia, it tends to retreat to its core mandate, focusing on refugees and asylum seekers, as well as stateless persons who are not refugees. So there is a lot of emphasis in UNHCR operations around registration and RSD, using diversified case processing modalities, trying as much as possible and as efficiently as possible to separate out refugees from migrants. Yeah? But this is a resource-intensive task that's quite challenging and difficult to do, especially in a context where migrants are so unprotected. Yeah. So this creates protection dilemmas for UNHCR. And in hostile environments where migrants and refugees are insecure and they're desperate, when UNHCR creates a practice that actually has positive protection outcomes, the demand for them becomes so high because of the lack of options that migrants have. So when something that UNHCR does is effective at creating protection for a migrant, for a person, a lot of other people want to access that. And that leads to fraud and corruption that then unfortunately compromises the practice itself and weakens protection outcomes. And there's several examples I can talk to you about the use of UNHCR cards, vulnerability screening for RSD and resettlement, and how these become very challenging practices to implement. So I think in summary, just to end here, effective protection for refugees really depends on the effective protection of migrants more broadly. They are in the same protection ecosystem. And so, without looking at the vulnerabilities of other migrants who may not be the classic refugee. And of course, there's a whole range of literature challenging a clear distinction between refugees and migrants. Nevertheless, there are lots of people who are in very vulnerable situations, and UNHCR's efforts to extract and identify some smaller number of refugees from this broader movement of migration is extremely challenging. So I'll end here, Cathryn, and I'm happy to look at questions and engage in conversation later. Thank you.
Great. Thank you so much, Alice, and for timing it so beautifully. So I should have mentioned that Alice and I are working together in the context of my RefMig project, which has a whole strand called Recognizing Refugees. And we're really trying to recenter and globalize the study of refugee recognition practices. And in that respect, then, it's a great pleasure to introduce my two RefMig colleagues who are speaking next, Dr. Caroline Nalule and Dr. Derya Ozkul. Their paper is entitled Handover of RSD from UNHCR to States, Motivations and Outcomes, and it compares practices of recent handovers in Turkey and Kenya.
Hello.
So hello.
I will share the screen first.
Okay, yeah. Yeah, showing. Yeah, that's fine. Yeah, so hello everyone. I'm glad to be here and to take part in this wonderful conference. Our presentation, Derya and I, follows neatly from the previous one by Alice, where we would like to cast a spotlight on the process of handovers of refugee status determination from UNHCR to states. So RSD handovers, next slide, Derya. RSD handovers have taken place in at least 30 countries globally. There is little scholarly attention. sorry.
Can you see the slide?
The next slide, please go to the next slide.
Yeah, I am. Yeah. Just a second, we need to.
Okay, yeah. So there is hardly any systematic or critical assessment of the before and after picture on refugee protection in the countries where handovers occur. Available literature is mainly by UNHCR in its evaluation reports. Scholarly scrutiny remains sparse. So we seek to examine the practices in Kenya and Turkey, two states where UNHCR had some of its largest RSD operations and which still host relatively high numbers of refugees. UNHCR has recently handed over RSD to state authorities, and the process has happened at about the same time in both countries. But we also note that there is no framework under the international refugee regime to guide handovers. States remain primarily responsible for it, as UNHCR is obligated to hand over the function when states so demand. So the dynamics will vary from country to country. And in this presentation, we share some of our preliminary findings and observations.
Caroline, can I just ask you to share, because I think mine is not working properly.
All right, sorry, we'll pause a bit. So in Kenya, the motivations for the handover were really were quite kind of mixed. So first of all, there was the local and international pressure to domesticate international refugee treaties and for the government of Kenya to fulfill its obligations towards refugees. So this prompted the enactment of the Refugees Act in 2006 and regulations in 2009, which also provided a legal imperative for the government to take over RSD. So the process was quite slow, and there was a work plan developed between the government and UNHCR, but this work plan was appended in 2014 following a terrorist attack, and a terrorist attack in the capital of Kenya. And the government demanded that it take over RSD with immediate effect. And as we shall see, security concerns continue to loom large over refugee management in Kenya.
So in the case of Turkey, RSD was handled by UNHCR until 2018, when the government decided to take it over. The handover followed Turkey's first asylum law, which was prepared and enacted in the context of accession negotiations with the European Union, and the subsequent establishment of the Directorate General of Migration Management in 2013, as I will keep saying in this talk, DGMM. So this period coincided perhaps unexpectedly with the uprisings in Syria and the gradual arrival of Syrian refugees, more than 3.5 million Syrians in the country, for whom Turkey decided to provide temporary protection. The large number of Syrians, coupled with the worsening economic circumstances, were followed by growing discontent towards Syrians, to the extent that return of Syrians became one of the most contentious issues in domestic politics. Asylum became increasingly securitized, and with rising number of irregular migrants in the country, in September 2018, DGMM decided to take over RSD.
Following the appended work plan, there was a rushed handover in Kenya, and the government lacked the infrastructure for its RSD operations. So what is pertaining presently is that the government is in charge of RSD from registration to decision-making, with reduced UNHCR staff involvement, but the entire operation remains heavily financed by UNHCR. That's providing infrastructure, equipment, and also paying the salaries for the government staff that are working on RSD. The government is slow in picking up the financial cost, at least in the short term. And UNHCR also continues to be the visible face of refugee protection in the country, being fully in charge of service delivery and coordinating humanitarian assistance. But we also see that there is a tug of war that is existing between the government of Kenya and UNHCR over data protection. The government uses UNHCR's Progress database, which has accessibility restrictions that the government is discontent with. So we see that there is refugee protection versus security concerns. But we also see that securitization has heightened within the refugee management with a heavy military presence of managers. Most of the managers have a military background. The refugee body was downgraded to a secretariat within a Ministry of Interior. At some point, they were only profiling new Somali arrivals and not registering them through the RSD process. And we also see renewed efforts to relocate all refugees to the camps in Kenya from the urban areas. But also there is a lingering concern of handing over to a state that continues to grapple with good governance, especially with its high levels of corruption. There is uncertainty there on the efficacy of the process.
So in the case of Turkey, although the handover was preceded by years-long preparation of the asylum law and pledge to establish a national asylum system, and UNHCR's ongoing training during the rather short transition period, the handover still seems to have happened too quickly. So yes, before the handover, DGMM established offices in every city in Turkey for registration. And in 2018, they founded the decision centers in Ankara and Istanbul with an idea to professionalize RSD decision-making. But the process did not include the voices of the civil society, asylum seekers, and refugees. And seemingly there was little reflection over whether DGMM's infrastructure was ready enough for this transition. Indeed, at the time of the handover, there were still not adequately trained RSD staff. The COI unit was premature, and RSD staff worked on a rotation principle, so reportedly the turnover has been quite high. So in the face of these limitations, UNHCR continued providing DGMM staff with training and hands-on support for RSD interviews. But UNHCR's position has also been quite precarious because it can only continue its support only at the invitation of DGMM. So today we see that there's still need for specialized RSD staff who are trained, professionalized, and who do not rotate but stay in the same job.
So what have been the effects on refugee protection? I'm sorry, my slides are not turning anymore for some reason. I don't know why. But anyway, we'll continue. So on the effects on refugee protection, on the upside, there is continuity in UNHCR ethos and some of its good practices. For example, the case processing modalities, including simplified RSD for specified groups, which reduces processing times. And also the recognition rates still remain high and rejection rates are estimated at about 5%. There is also the establishment of an independent appeal body with a prospect of judicial review, which further strengthens the refugee protection regime. Yet on the downside, the handover has exposed the lack of transparency in these processes, especially to those most affected, the refugees and asylum seekers. Lack of information and poor communication caused much distress and uncertainty. Uncertainty also continues for the future of refugee protection in Kenya. There are mixed signals from government. On the one hand, there is the push for a more robust refugee law, which is at its second reading in Parliament. Yet on the other hand, there are government announcements to close the camps and repatriate refugees, which way then, it's a bit hard to tell at the moment.
Similarly, in Turkey, on the upside, unlike UNHCR's RSD, government's RSD decisions can be appealed in administrative courts. But for this, there is a need for more judges trained in refugee law. And I must note that, like in Kenya, it is very difficult to make a before and after evaluation because RSD decision-making processes are not transparent. So for example, we don't know currently whether specific vulnerabilities of applicants are considered. What we have found so far from our interviews with former UNHCR staff who worked during the handover period is that DGMM's RSD decisions are not reviewed by any senior officers like in UNHCR. Moreover, DGMM is reported to have rejected some of UNHCR's previous positive decisions after the handover. Our interviews also show that the quality of decision-making has been vastly different. So for example, the quality seems to differ according to the city where a file is assessed. In some cities, applicants are reported to be rejected based on very superficial reasoning, whereas in decision centers, officers are reported to be following UNHCR's training more closely. So overall, the quality varies, and it is too early to make any conclusive statements, but in its current state, it seems to be lower compared with the pre-handover phase. We can also find this in statistics, whereas previously, for example, UNHCR recognized most applicants from Afghanistan and Iraq. The following year of the handover in 2019, DGMM has rejected more than 50% of applicants from these two countries. So if you can go to the next slide. So what we can learn from, what are some of the lessons we can learn from these two case studies? The cases illustrate that there is really rarely a comprehensive preliminary assessment on handover's impact on refugee protection, government's ability to function, to carry out the function effectively, and on how the handover can be implemented with minimal upheaval for refugees and asylum seekers. So therefore, overall, what we find is that handovers expose really some of the weaknesses in the international refugee regime and lack of an effective oversight mechanism. Post-handover, the future of refugee protection depends mainly on how much a state is willing to invest in it. So our preliminary research leaves us with another yet equally important question of what role can refugees play in handover processes besides just being objects whose lives are transferred between institutions. So we explore some of these processes more in detail in our piece in FOMR and our forthcoming RefMig working papers, which you can find on our website. Thank you.
Great. Thank you so much, Derya and Caroline. And it's so wonderful to hear that research just crystallizing into some ideas, even though obviously there's still research ongoing. And I think when I look at the two papers side by side, I think Alice brought out really the constraints that UNHCR works under sometimes with host states who are reluctant hosts for refugees. And at the same time, I guess we have this default institutional commitment that UNHCR has to that it's both in favor of states taking over the RSD function and that it sees that it's something that will foster refugee protection. But of course, there's no guarantee that a newly created state apparatus will recognize either the right refugees or even in a way, any refugees. So I think it brings out some of these dilemmas around handover practices really well. So turning then to our third presenter, we have Didem Dogar, who is a researcher based at McGill University in Canada. Her paper looks at UNHCR's exclusion practices and is entitled "The Role of UNHCR in RSD, Protection Without Impunity?" ? So welcome, Didem.
Thank you very much, Professor Costello. I am really happy to be here, well, visually, and part of this conversation today. So let's start sharing. Okay. So in this presentation, I will evaluate the UNHCR's legal obligations when it conducts refugee mandate refugee status determination, RSD, in states where it has a state substitute role. The focus will be on the UNHCR's role in the implementation of the exclusion clause, Article 1F of the 1951 Refugee Convention. Specifically, this research examines whether UNHCR, mandated to protect persons within its field of competence, has any duty to assist the prosecution of excluded persons in states where it takes over the exclusion adjudication process as per Article 1F. So the main argument is that UNHCR as an international organization has certain obligations regarding international criminal prosecutions. Due to its evolving functions, UNHCR could be concurrently liable for the failure of prosecuting excluded persons together with host states, where the credible evidence collected by the organization during its RSD process and where it is a legal obligation for the host state to extradite or prosecute alleged offenders of Article 1F acts. I'd like to underline that in this presentation, I will only hone in one obligation to extradite or prosecute. In explaining this argument, I will first analyze UNHCR's established practice regarding the RSD process, then proceed with the duty to extradite or prosecute, and conclude with the possible drawbacks and solutions for the dilemma. So states have the primary responsibility for determining the status of asylum seekers. Sorry, I think my screen sharing is paused. I should figure out this. Yeah, okay. So states have the primary responsibility for determining the status of asylum seekers, but UNHCR may do so where states are unable or unwilling. In almost 70 states, including Lebanon, Jordan, Malaysia, and Egypt, UNHCR conducts mandate refugee status determination. In some countries, as mentioned by Alice earlier, UNHCR acts to a great extent as a surrogate state, performing a state substitution role, but without the capacity to fully substitute for host government. An exceptional role has become a general norm. The UNHCR's conduct of RSC points out the evolving and expanding function of the organization from a mere supervision. So this will take me to my second point. If in countries where UNHCR conducts RSC, it was state authorities conducting RSC, would they have any obligation under international law stemming from the exclusion adjudication process? International law recognizes obligation on states to enable prosecutions under the principle of aut dedere aut judicare. The principle obliges a state which has the custody of a person who has committed a crime of international concern, either to extradite the offender to another state, which is prepared to try him, or else to take steps to have him prosecuted before its own courts. Among Article 1F crimes, an obligation of aut dedere aut judicare applies to first war crimes amounting to grave breaches within the context of an international armed conflict under Article 1F war crimes, and second, an act of torture under Article 1FB serious non-political crimes. States may become aware of evidence about international crimes of mandatory universal jurisdiction, including torture and some war crimes during the RST process. The United Nations Principles to Combat Impunity stipulates that host states must ensure to completely fulfill any legal obligations they have assumed to institute criminal proceedings against persons about whom there are credible evidence of individual responsibility for serious crimes under international law. Host states often violate their international obligations if they have collected credible evidence, but do not launch criminal investigations against excluded persons for the mentioned crimes. Yet, all these obligations are akin to the state's world. What happens in the world of UNHCR, which is an international organization? Can we apply the principle to prosecute or extradite to the work of UNHCR? International organizations with international legal personality are only subject to international law to the degree that the nature of their personality dictates. Having a separate legal personality as per the ICJ's decision, UNHCR has duties and rights in the international law arena. We question whether one of these duties includes assisting host states for crimes triggering their obligation of aut dedere aut judicare arising as a result of the exclusion analysis. The key point here is the developed practice. UNHCR is not required to act on excluded persons under its mandate. However, under international law, requirements do not only derive from the explicit duties stipulated under an international organization's constituent instrument, but also developed in practice. As such, wrongful acts can be ensued from the omissions of an international organization in fulfilling its requirements that derive from its developed practice. Determining what constitutes the developed practice of UNHCR will identify its duty, if there is any, for the post-exclusion phase. The evolving and expanding functions of UNHCR indicate that analyzing extraterritorial international crimes through the exclusion assessment is its proper practice. Like states during the RST process, UNHCR may become aware of credible evidence pertaining to international crimes of mandatory universal jurisdiction, such as torture or some war crimes. Some of these crimes explicitly bring about the host state's obligation to extradite or to prosecute. In such a situation, either there's an effective information flow between UNHCR and the host state, or UNHCR has discretion not to share any information. In countries where UNHCR has the authority to decide on Article 1F cases, the UNHCR's liability coexists with that of host states to suppress international crimes under the concurrent liability model. However, for good reasons, evidence obtained in RSD proceedings is subject to stringent data protection and privacy constraints. Sharing evidence obtained in an administrative proceeding that provides less stringent safeguards compared to criminal law standards could also violate the principle against self-incrimination. Well, I analyzed the use of asylum testimonies in criminal prosecutions within national systems. For those who are interested, the relevant publication is on the slide. Discussing the UNHCR's role in impunity when it fails to share the information concerning suspected criminal acts is significant. It is a fact that UNHCR makes the exclusion analysis. If the organization fails in sharing any credible evidence on the acts of international concern with host states due to the confidentiality reasons, it still causes a safe haven. Although it must be disturbing to hold UNHCR accountable for its inaction, not questioning the UNHCR's policies towards excluded persons is creating another odd scenario whereby an organization working under the auspices of the United Nations tacitly causes the impunity for perpetrators of the international crimes. The fragmentation of law should not be a cause for turmoil, but rather an opportunity for constructive approaches. Shouldering all responsibility on UNHCR is far too much for a humanitarian agency to carry. The global community should find a solution to prevent this situation. The first step should be ensuring transparency and accountability in the exclusion process. The second step can be finding a global solution for excluded persons. To ensure objectivity and due process, the establishment of an independent international commission that will have responsibility and decision-making capacity over these individuals might be a feasible option. In conclusion, there's an impunity problem resulting from the governance of the international refugee regime. And to date, none of the institutions are held accountable for this situation. This is an urgent matter in dire need of examination by the global community. Ignoring it will only hurt the international justice system's nascent reputation. Thank you very much for your attention.
Thank you so much, Didem, for explaining such complex legal terrain so well, and also for taking on this really difficult question. I think there are very few legal scholars who've tried to really work out the questions about the implications and obligations of international organizations in this field. So next up is my paper with Professor Gregor Noll. So I'll just briefly share my screen also, and I hope this works. So before I hand over to Gregor directly, just to say that this is very much work in progress. And really, I've been very privileged over the past couple of years to be working with a team of researchers and some external colleagues also looking at different modes and types of refugee recognition. But what we're trying to do in this paper is something a little more conceptual and offer a new framework for understanding the diverse modes of refugee recognition. So I'll hand over to Gregor.
Thank you so much, Cathryn. And we're diving right in. It's wonderful to be here. I'll probably not tell you something new, that we have rather limited insights into global RSD, and much of what we know is about the North, and therefore the presentations we've heard so far are incredibly valuable. We know from social legal studies that there is a problem of discretion and credibility determination. You won't be surprised by me restating that, and that's mainly focused on what we put into quotation marks as individual RSD. Cathryn will explain in a minute why that needs to be taken with a certain caveat, that term individual and group. And then from political science, we do know that, oh, we have a lot of outcome variation. It doesn't look good if you try to follow more or less the same group as they vanish into different states, asylum systems, and, some get asylum, others don't do so. And if you just look at the law applicable, well, it should be pretty harmonized, especially in, the European Union, where you do have not only a layer of international, but also regional law, which tries to do harmonization work, but it's not going very well. And we also know that we know too little about UNHCR, RSD, and we know too little about RSD in the global south. There's a great paper forthcoming here by two of today's speakers, namely Nalule and Ozkul, which I had the privilege of seeing in draft. And I think that makes that point quite forcefully. So empirical insights we have, and considering what is the takeaway point of these insights, we can say that, well, we do have too little guidance by refugee law doctrine on evidential assessment, because that guidance is inconsistent. It's in part irrational. If you try to scratch the surface, you'll see that concepts like benefit of the doubt don't really make sense and actually can be indicted as being part of the confusion. And we are unsurprised by the fact that decision takers' discretion is such an outcome determinant, as recent machine learning studies have confirmed, because, well, if the law is not taking that space, the decision taker will take that space. So moving on to where we should go from this problem, and here we thought of different tracks. We see, of course, you could say, let's do more legal training of decision takers to shrink that discretionary space again. But what if the doctrine is incoherent and irrational? Then you would rather not train decision takers on it because the outcome will not be better. Could we employ more ethically minded decision takers, better human beings in a sense, and put them into the decision-taking position? Well, that would move the problem into a discussion of what ethics are and how a human resource officer would deal with the ethics question when employing a person. Should we have artificial intelligence nudge decision takers? Well, it's not unproblematic, because artificial intelligence and machine learning is about collectivizing and legitimizing bias. And, with the principle of junk in, junk out, if you have a historical material that is enshrining a certain bias, you will be biased in future decisions as well. So let's move to the more interesting aspects. One is to devise a new doctrine of evidential assessment. There's this great work by a colleague, Hilary Evans Cameron, you'll find in her Refugee Law's Fact-Finding Crisis, where she proposes a model of abductive reasoning. And I really recommend to give that a close look, and I do think Cathryn does so as well. But again, there are problems there. We might need to do further footwork before that could work, because the quantum of evidence, how much evidence we need for a person to be given refugee status, that's still unclear. And working away on second order norms as a rule on abductive reasoning is incomplete in doctrinal terms, as long as we have not a clear thinking on the quantum of evidence. So here we are. The intermediary conclusion is, let's reconsider RSD through the lens of group recognition. Let's try to make the quantum of evidence problem more transparent by doing so. Let's try to push the cognitive burdens of RSD into the foreground and see whether they're matched by cognitive resources and at what level. And as artificial intelligence is all about aggregation, reconsidering RSD as a kind of a group practice is an adequate tool to analyze what it does for RSD. So it's a bit future-proofing as well for the changes that invariably will come to RSD. Over to you, Cathryn.
Thanks, Gregor. So really what we're trying to do is recenter the idea of the group in RSD practices. But in doing that, actually, we're really keen not to set up a sharp dichotomy between individual and group practices. Rather, we're thinking of these very much as a spectrum. Just before we get into that, I wanted to just highlight that often when we imagine group and individual processes as distinct, it's actually resting on what we've called these bad binaries. So I just wanted to name them and move them out of the way, if you like. So sometimes there's an erroneous legal supposition that the 51 definition is somehow about individuals, and that groups of refugees recognized as such as something that belongs more in the expanded regional definitions. And that's not doctrinally correct. It's also not a good way of thinking about the institutional practice either. There's also sometimes an unhelpful notion that, in normal times, you have to have an individualized refugee process, and that group or prima facie in particular recognition is for times of mass influx. And that's, again, also not legally warranted or empirically accurate. And there's also this very unhelpful notion that individualized RSD is the gold standard. It's what we in the global north do, and that prima facie in particular or other group types of processes are for the global south, for Africa in particular. And in fact, really, we reject all of those binaries. I think, if anything, what it might be helpful to think about is that in many systems, especially in Europe nowadays, we've gotten used to the idea of safe country of origin and presumptions that someone is not a refugee, but actually presumption that people and groups are refugees, and that we can tell that fairly easily, actually should be central to decision making. So in that, actually, I think in many respects, we're echoing an earlier piece by Jean-François Derya. And we both agree with Jean-François that a measure of group-based determination is inherent in most RSD. And what he does, writing in 2008, is identify practices at 7 different levels where you may find group or group-based recognition, or what he calls groups at risk. And note that that can take place at a very high political level, collectively, or within individual decision making. And we really share that insight and wanted to build on it, that it can be intrinsic to the individual case. Now, I think if we turn to my next slide, what I wanted to focus in a little bit, just given the theme of the panel, was the role of UNHCR here. So UNHCR, and this is on the next slide, has this role, as we've discussed, in mandate RSD. I think historically, it's fair to say its role was much criticized from a very individual due process point of view, and indeed that critique was impactful. So Professor Chimney, whose wonderful keynote you heard earlier, in 2005 identified this as a really interesting context in which there was successful resistance within a framework that he was discussing of global administrative law. So there was very powerful scholarship in the 90s and early 2000s from Alexander and Kagan, a powerful joint NGO statement to Oxfam saying RSD processes don't meet individual justice standards, and then UNHCR adopted procedural standards. There's now a new iteration of them. So this story about individual due process, I think, is a really interesting one. It's not precisely where we're focusing today, but I don't want to discount the importance of it or say that this story is over at all. Instead, what I think we wanted to focus on today was thinking about UNHCR as an actor that engages in setting up presumptions of inclusion. So both in their own practice and also in the role that they have in country of origin information. And I was really interested when I saw that back in 2008, Jean-François Derya noted that UNHCR is very limited in its role in this area. And what he was focusing on there, and he took as an example, was country guidance on Afghanistan, and how UNHCR is very hesitant to state publicly that a group of people are refugees. And what you'll see on the next slide, and this is really where we're really still doing research on this topic, is that when we look at UNHCR in this context, I think we really can ask the question, has a lot changed since 2008? And certainly on paper, a lot has changed. So for example, in 2016, UNHCR issued new strategic guidance or a new strategic approach on RSD, and it commits the institution to using strong presumptions of inclusion, and then what it calls diversified case processing modalities. I wish these things had nicer language, but using presumptions of inclusion to get to a position where there's no longer a focus on the individual applicant and their testimony, the consistency of their utterances, and all of that individualized focus that we know in the European context often leads to the rejection of strong claims. So that's some of the background in terms of UNHCR. Gregor, I'm too behind in the slides, but I think this is the point where you pick it up again in terms of the new typology that we're trying to develop.
Okay, thank you very much. Well, now, Cathryn has done a lot of rejecting of binaries, so you guys might be wondering, what are they going to talk about at the end? And now I wish there would be this wonderful slide, but yeah, for some technical, oh, well, here, there it is. That's the new taxonomy, and it's very simple. You simply look at refugees recognized as group and individuals. That's the yellow horizontal line. You'll easily see a kind of a flip back into earlier discourses, but the difference is that we are also looking at decision makers who can decide collectively and individually. And there's obviously a kind of a, that's not a binary, but there's a line here. There are very different ways ranging from a more individual to a more collective way. And if you just have a look at the box on the lower end of the right side, single decision maker is assessing an individual case. There you are really having the epitome of northern, global north, RSD, individualized, where a calm decision maker is sitting and having an individual in front of her or him and, hearing the case, taking a decision. But you know very well that this doesn't hold water because there's country of origin information. There are precedents that the decision taker is looking at. There's a whole lot of people that already have been seized with the question of whether that person should have protection or not. So individual never means fully individually. So would you think about that collective by, for example, associating to an appellate court, which rules in an individual case? Well, then you are moving more towards the collective domain. To be even more concrete, when we're talking about groups, you could, of course, associate to the Council of the European Union taking a decision on temporary protection, which never happened, or on the crisis mechanism, which is proposed by the Commission to be part of the new pact on migration. That would be a collective decision on a collectivity inflow of sorts. But you could also look at the German practice in 2015-2016, where Syrian applicants were decided on in a rather uniform way, where 95% or so got protection. And well, they have been given individual decisions, but it was pretty much a collective practice, wasn't it? Everybody seemed to agree on it. There was an institutional practice there. So with this grid, I think we can propose a kind of a more orderly way to talk about refugee status determination without slipping into cliches, so to say. Now, yeah, perhaps we're at the thank you stage. Cathryn, is that what we're at? No, we're doing the risks as well because we don't want to sell something. Yeah. And that's the last slide then. A couple of caveats here. The overall cognitive burden handled by refugee status determination would be no less in a collective setting of, well, decision making on a group and by a group of decision takers, but it would be differently distributed. And it's really a good provocation to our thinking that we need to think through that difference. Powers allocated to individual decision takers today might be concentrated at an aggregate level, and that's magnifying error risks. We know that, we've learned that lesson from UNHCR RSD. When it was in a dismal state before these reform efforts, we saw how much power it concentrated in poorly trained hands, if you allow me to be frank. There is also an amplified focus on identity following with collective decision taking, where the question is, do you belong to that risk group that is deemed collectively to be entitled to protection? And that is reflecting the importance of the work by Didem here. There will also be an amplified focus on exclusion. because if you handle people as a group, the question comes to you where you place the exclusion considerations in the process. So having said that, I hand back the word to Cathryn.
Thanks, Gregor. So I think as people can hear, we're really interested in your insights and responses. And we're really just trying to propose that this typology gives, a way of looking at these spectrums in two different directions. So we've already had a lot of questions, and maybe I'll just put them to our speakers in the order that they spoke, if that's okay with you. We have about 20 minutes now for questions. So yeah, Alice, I don't know if you've had a chance to have a look at the questions that are posed to you, but you had a question from David and quite a few others of the general ones. I don't know if you're ready to take them, and then I'll go in the order in which we spoke. So yeah, you're muted. Yeah, you're muted.
Sorry, thank you so much for the comments. Thank you, which are very insightful and thought-provoking. Yes, definitely, David, the state is, heterogeneous, and you have contradictions within the state. So in the COVID response, for example, the health ministry said that it would not arrest migrants and refugees when COVID testing was taking place, and they could go to hospital facilities for treatment. But then, like, soon after that, a few weeks later, and they would not arrest anyone. And then immigration started raiding, doing raids and operations. So you have inconsistencies within the state, and I think that's really quite frustrating for everyone. And so definitely, the state is not heterogeneous. I've been thinking about, how can we create more consistency? Because in a context like Malaysia, where, there's so many blurred boundaries and lines and everything is subject to negotiation, in the absence of Malaysia enacting domestic laws, because we've always oriented about the legal framework, could something else suffice? So, for example, standard operating procedures, ways of administratively creating, standardized, predictable practices that may not reach the level of law, but still have some sort of everyday effect. So maybe that approach might be helpful. I mean, the inconsistencies that you point out are not even between parts of the government, it's even within the same, government unit. So one immigration officer in one location could be very harsh and, anti-UNHCR. Another immigration official may be sympathetic, So the level of discretion is quite high and the inconsistencies are quite high. Yeah. I'll probably stop there because there are a few others and maybe we can come back for a second round.
Thanks, Alice. That was great. So I guess Derya and Caroline next. You had quite a few actually. So I don't know how you'd want to divide them up between you.
Thank you. I think I'll start with a question from now on whether it's wise for states to be, for UNHCR to be handing over to states rather than the other way around. So, and also the role of resettlement, the implications on the resettlement process. So I don't think with states doing RSD, it would have any significant implications on resettlement, because at least in the countries we are looking at, UNHCR still plays that mediatory role. So even as states are doing RSD, UNHCR will take over if it comes to resettlement. And we know that states usually share their resettlement criteria with UNHCR and not necessarily with the state. So that function will still be with UNHCR. But also regarding the wisdom in UNHCR handing over to states, UNHCR is kind of like in a catch-22 situation when it's doing RSD, and at the same time, it's supposed to maintain a supervisory role on the process. So we know that from prior research, that UNHCR may not efficiently carry out the refugee status determination. There have been many criticisms of it doing so. And at the same time, it has to maintain that effective supervisory role. So I think yeah, there is some there is some sense in states doing that function and UNHCR retaining that the role that it's supposed to play. And also it would still continue to, and this I link to the next question asked by David about UNHCR's role in a fragmented kind of like decision-making environment. UNHCR still continues to do its mandate RSD in parallel to the state doing its RSD as it does in countries where governments have taken over RSD. But it also places UNHCR in a better position at times when it's outside of the conflict happening between different government departments. For example, in Kenya, UNHCR is no longer in the direct line of fire. The Kenyan refugee status body is within the Ministry of Interior, which of course is so intent on the security side of things rather than the refugee protection. But one strategy of UNHCR is working through local actors, though it's not deliberate, but it has been one of the kind of like outcomes of it, and that is working with the CSOs that are involved in strategic litigation and CSOs that are also political actors in the sense that they actively lobby parliamentarians and other local actors. So we see that with UNHCR in this kind of place, it can still be effective in changing the environment, even as there are these fragmented approaches between state departments. Thank you.
Great. Thanks, Caroline. Derya?
Yeah, if I can add a few more points perhaps. So yeah, in response to David Cantor's question on state being fragmented, yes, absolutely. So especially in terms of refugee protection, UNHCR is trying to, trying to work with the Ministry of Health at one point. They're trying to also work with the Union of Bar Association, trying to give training to lawyers. But at the same time, they also have to be in good relations with the Ministry of Interior. I'm talking about the pre-handover when they were doing the parallel procedures. So it is a very difficult position to be. Yeah, but at the same time, I mean, for RSD, actually in Turkey, this was it is an interesting example, because before the handover, they were doing the parallel procedure where UNHCR was doing RSD, and the state was mostly were accepting UNHCR's decisions, except a few cases where there were very political reasons, but it was very, very, very exceptional cases. So the kind of pre-handover state and UNHCR were working kind of similarly on RSD decisions. On Noah's question for UNHCR's, whether UNHCR should be doing RSD for resettlement, I mean, whether they should be continuing RSD, if I understand correctly. Yes, and it is, I mean, that is happening that way at the moment as well. So UNHCR still continues doing RSD for resettlement purposes after the handover, which is merge RSD modality. But they can only look at the applicants that are given conditional refugee status by the states. So it has to go basically through the state first, and then it can come to UNHCR only. But again, resettlement states do not accept Turkey's examination alone. So they still ask for UNHCR's decision as well. There was a question on the pandemic as well. Yes, the pandemic has caused a lot of problems, and unfortunately it happens, I mean, in the case of Turkey, it happened just 1 year after the handover, when there were already some problems after the handover, and then the pandemic happened. So RSD interviews stopped right after the pandemic, when the pandemic started, from March to August 2020, and still there are many problems in terms of even accessing registration. Just last question on Jean-Francois's question on group recognition, and maybe this is also related thought to Cathryn and Gregor's talk as well. So yes, so when, for example, when UNHCR was doing kind of group recognition for Iraqi applicants in Turkey, exclusion was really a major issue. So that risk of aggravating exclusion was indeed an issue. So we have to think about that, how to counter that, basically, that problem. Yeah, thank you.
Great, thank you both so much. Didem, you have a really great question there from Maya Grundler. Do you want to take that one?
Yeah, I think there are two questions. So I will go first with Maya's. Okay, if I can find it again. Okay, so isn't UNHCR's involvement in criminal prosecution, basing such prosecution on exclusion from refugee status problematic, given the low standard of proof in Article 1F, which is serious reasons for considering? Yes, I mean, you're right, Maya, that in such a case, there is probably no basis or enough sufficient basis to start prosecutions. However, as I stress out in my presentation, it's mostly when these serious reasons for considering, or the evidence that UNHCR collected during the RST processes reach to the threshold of credible evidence. And how could it be? In which cases, like in cases, for example, the person is a well-known, like the asylum seeker is a well-known suspect, and somehow hides his or her identity from state authorities and then declare it during the RST process. And with a, let's say, quick Google research, one might find out the person is a perpetrator or suspected perpetrator. Or in refugee camps, for example, sometimes witnesses say and inform UNHCR that this person that tortured us or this or that. So in those cases, I think we can argue that there is sort of credible evidence to start or launch in normal conditions to launch criminal investigations, at least investigations, which might not end up in the in prosecution, but at least investigation to start. So in cases where the link is really low, the link is really, let's say, unclear, yes, it will be difficult. Let's say that during Iran-Iraq war in 1985, a soldier from Iraq coming and seeking asylum in a neighboring country, where the conflict was really, intense during that time, that would be more difficult to say that there's credible evidence to start criminal prosecution. But as I said, it's always credible evidence. And this might be the case for some exclusion cases from UNHCR, because UNHCR is very, very, very careful in excluding people. If you look at the guidelines, they do proportionality analysis at the very end of their assessment. This in and of itself can prove that the ones that are excluded by the UNHCR can actually, those cases can reach the threshold of credible evidence, in my opinion. So there's another question that does the UNHCR data share with any state, or does it have standards? We know that UNHCR has shared information about Uyghur dissidents with China. Will it data share with states where the person might suffer torture, problematic treatment? I think if that was related to the prosecutions and the concerns, I assume, Nicola, I think it's an excellent point, and that's one of the concerns that we should give a merit to. However, it doesn't really affect the normative framework, in my opinion, that this causes impunity. Pragmatically, pragmatic scenario, yes, there can be problems such as sharing this information, and the country that UNHCR operates in has really low standards of due process of law, or the country can use it for other reasons. That's the reason why I suggested to have a sort of international commission that will operate separately from UNHCR in order not to harm the humanitarian nature of UNHCR. That way, international commission can tackle with such a situation. Although there is another concern, if there is such an international commission, who will spare budget for such an international commission? Who will, really realistically start in this area where everyone is pulling out the financial contribution from host states' contribution from, UNHCR? How to establish such a commission? Those are all valid concerns, I guess, but that should be discussed. I think that's the point here. Well, thank you.
Great, thanks, Didem, and thank you for the great questions, everybody. Gregor, if it's okay, I think I'll pick up two of the questions and then hand over to you. I think there was a great question from Fenko Vogelar about country of origin information. And of course, we've learned a huge amount from your scholarship, Femke, on this topic. I think what we're keen to do is distinguish between information in the true sense and sort of various forms of country guidance or protection considerations. And really what I think very often in this field is that those sorts of guidance, and that can be internal documents or more formalized documents. But I think even packages of what we call country of origin information are often sort of making provisional legal assessments. So they fit into this broad heading of like, they should, or let's say, forget about should, they often turn on sort of setting up presumptions for decision makers. And I think I would want to distinguish very carefully, and this is getting into more normative terrain, between framing generalities that set up presumptions of inclusion compared to generalities that set up presumptions of exclusion. And I think we've somehow lost this difference. And I mean, this is the wonderful, I think, message that comes through very clearly also in Hilary Evans Cameron's book about the relative risk of error in asylum. Like rejecting somebody, you have to be really sure about that. Including somebody, you know, I think there are good reasons to just have an asylum system that, you know, often is able to work on a presumption that the applicants are refugees. Because why else would they flee and claim asylum? You know, in Europe, we just got totally head up with the idea of bogus applicants. But, you know, for the most part, people claim asylum because they have international protection needs. So I think, you know, I just think we haven't mapped this yet in the paper, but we need to do some more work, I think, thinking about distinguishing between like genuine, you know, information on the human rights situation in a country, and then more digested reports and protection considerations that kind of can help decision makers just profile applicants and work on the basis of presumptions of inclusion. And I suppose what I was suggesting in a slide that got slightly glossed over is that what it seems at this stage is that certainly UNHCR isn't as reticent as it used to be when Jean-Francois was critiquing the framing of protection considerations on Afghanistan, or at least in the case of Syrians, but that might be the outlier, has stated quite clearly that it can be assumed that everybody fleeing Syria is a convention refugee, or not everyone, but like most people. There are a variety of risk profiles, but the net impact is that if you're fleeing Syria, you are in likelihood a convention refugee. The second question that I wanted to pick up on, and I hope we could have further discussions on this, is from Patricia Hines on, do we need some sort of multi-agency structure? Thinking about child protection as an analogy. And I mean, this is where I would really like to do more work. I mean, if we were talking about how do you make things better, and we're not at that stage in our paper, Gregor and I are really trying to do more mapping and conceptualization. But there are asylum systems that are explicitly tripartite, like in Brazil, or even in Italy, UNHCR is still part of the decision-making structure. And you can really imagine a case for, like what we know is that asylum systems recognize more refugees if they're insulated from certain types of politics. On the other hand, Gregor and I are saying, well, sometimes you can make a collective decision to include a group of refugees, and that might be done at a political level. So let's not assume a priori one type of body is better than the other, but what we do know is that, you know, certain actors are very likely to be subject to political sway. That means that there will be political pressures very often not to recognize refugees. So thinking about a you know, in lots of areas of adjudication, you have this tradition of having panels with different types of representation on it. You have it in labor law in many countries. So I think thinking through that idea of adjudication by actors with different sets of interests might be a very interesting way to think about RSD, also in terms of institutional design questions. So that suggestion is really a really helpful one. Gregor, I think I'll hand over to you for the final word then. So,
Cathryn, how am I to interpret that final word? Goodbye and thank you, or can I still answer a question?
We have 4 to 5 minutes. Yeah. Oh no, for answering questions for sure. So.
That's eons of time. Then I can be a bit selective. Rabia and Rifat asked about whether we propose criteria. And I think it's fair to say, Cathryn, although we are inventive, we're not that inventive. I don't think we are kind of bold enough to do that type of prescriptive work. What we are after is that any system is transparent enough for us to understand how decisions are made, and in particular, transparent enough on the quantum of evidence, on what is required to be included. That's a kind of a basic demand, and then we can discuss different solutions to bring that about. More individual, more collective. So sorry, that's a very short answer to a complex and important question. Caroline, you asked whether playing the group game wouldn't further an externalization practice, which things in collectivities of persons who are not really welcome to have their case determined in substance in the global north. And I think that's where I would put the emphasis, and I hope to have you with me, Cathryn, here. Externalization is very much about not letting cases go to a stage where they're substantively assessed in the global north, in the externalizing state, but to hand over, to push over that responsibility to a state which is usually less well equipped in terms of cognitive resources to handle that caseload. So yes, there is a linkage, you're quite right, but I wouldn't see automatically that whenever you go group or collective, you are playing into the hands of persons who are promoting externalization as a collective practice. Then there was a good question by Nicholas, or Nicholas perhaps, which is about asking us to elaborate a bit on the AI dimension. And there I can very briefly just remind you that machine learning is about processing a huge load of cases, and a huge load of cases means group determination, both in terms of it's about a lot of applicants, but it's also about a lot of decisions taken by a lot of decision takers. So if you think about the way machine learning, artificial intelligence could be built into asylum decision taking, it's emphatically on the collective side, both when it comes to processing individuals and when it comes to processing decisions. So with an enhanced group analysis, I think we're better fit to capture what exactly is happening if we're building that into decision taking at some level. And finally, just a little footnote to Femke. I just can't resist the temptation to say something. And yes, I do think your research is great too. I was thinking that when it comes to country of origin information, we are of course interested, and we should be interested in how prescriptive is it. And if it is prescriptive, we're again asking for transparency about the quantum of evidence that is either displayed or influenced by that country of origin information. And then come all the considerations that Cathryn already was transparent about. I think that's where I'll have to stop. There's much more interesting stuff out there in the question you asked. Thank you very much.
Great. We are remarkably on time, bringing this really fascinating panel to an end. I'm just so sorry we're not in person to have, the drinks and continue this discussion. One point that I wanted to make, just that came up in the chat a little bit, is that one of the comments actually said about data sharing from UNHCR, and I think the comment actually refers to a different UN body, but in fact. And then I think Didem sort of understood it as an allegation against UNHCR, but we've just put in the chat, UNHCR does have data sharing standards. And I think Didem was very careful to acknowledge that these obligations in relation to international criminal prosecutions and the data sharing dimension are in tension with each other. So I just want to join all the speakers. We covered a lot of ground, and thank you all for your great presentations and for keeping to time and answering the questions so well. I hope you can all see that this ongoing endeavor of the RefMig project to try to understand refugee recognition practices better is a huge scholarly and practical challenge. So if you're interested, please do get in touch. We're currently engaging with UNHCR decision makers, former decision makers, legal aid providers, and trying to build up a much more accurate evidence base. So if you're interested, look up the RefMig project or just drop us an email. We're really interested to hear from anybody who has practical insights into these processes on the ground. So thanking you all very much. Thanking David and Sarah for running an amazing conference under the current constraints. And I'd like to remind you, and David has just put in the chat, that you can jump straight to the final session now, which Sarah is going to lead. And thank you all once again for your presentations and your questions. And I look forward to continuing to work on this important topic.